Bill Erhard from Estate and Elder Law Services. I'd like to talk to you today about blended families or second marriages. It's a fact that needs no independent confirmation that half of all marriages in America today end in divorce. More likely than not, if someone gets divorced, they get remarried. One of the common estate planning problems that we face in our office is second marriages, where the spouses come into the marriage with their own assets and resources and also their own children. Typically, what spouses want to do is they want to provide for one spouse, but they want to make sure that their property ultimately gets passed on to their own children and not somebody else's children. So we can use trusts in a variety of ways so that when one spouse dies, assets are left in trust for the benefit of the second spouse. But then when the second spouse dies, the assets go to the first spouse's children. We do this frequently with IRAs. If one spouse has a significant IRA, we don't make the second spouse the beneficiary of the IRA. If the spouse is the beneficiary of the IRA, he or she can roll that IRA over into their own name and then leave that IRA to their own children. So what we do is we create a retirement trust. The beneficiary of the IRA is not the spouse, but the retirement trust. The IRA pays the required minimum distributions into the retirement trust, and then the retirement trust passes them on directly to the second spouse. If the second spouse needs more than the required minimum distribution, he or she can apply for that, and the trustee can make additional distributions if necessary. But when the second spouse dies, whatever remains in the first spouse's IRA is then passed on to the first spouse's own children.